All right, good evening. I'm Alex Glavos. I appreciate you all for joining me. So we're going to go through a lot of things tonight. I know everybody's doesn't want to be on this forever, but I want to go through the topic of the conversation. I'm going to switch over to the PowerPoint. Let's do my screen share. Okay, so my firm is located in Jericho, New York. This is what we do. There's some ancillary matters, but we are a family law and divorce firm. I've been doing this since 1997. We're all getting a little bit old. I feel like I'm getting old. I am married. I have 4 kids, and I've been through the gamut of problems with my kids, with my wife. We've had our problems too. And frankly, being a divorce lawyer probably helped us through some real hard points because of all the things we've seen. So the first thing I tell my clients, before that, I'm going to go over what we're going to cover today. So the question is preparing for divorce and are you ready for divorce? And at the end of this, I'm going to email all of you this. It's about a 20 to 23, I think it's 23-page manual of an outline to help you get prepared. Prepare for your first meeting, prepare for filing, just in general to answer some questions to help you be organized before you speak to an attorney, whether that be us or somebody else. So the first thing I often tell clients, and it confuses them, I think, because what I tell them is we're not in the business of breaking up marriages. We're in the business of protecting relationships and protecting your assets. So I ask my clients, and I've had many that once I ask these questions, they go home, they don't get divorced anymore. They work on it. They try to think about why they're there. They haven't thought about the ramifications. So I'm going to ask a few questions that I want you to ask of yourself. I'm looking down because I have the full manual that you're going to get. So first, why are you here? What are you reacting to? Are you reacting to something temporary? Is it stress, grief, some other unrelated trauma? Is this a one-off while you're here? Was there one transgression like cheating? Is it emotional infidelity? Is it dead marriage? Have you tried counseling? Have you tried mediation? Have you tried really open conversations? Really, the real question is, are you making this decision from clarity, not necessarily anger? The financial reality you have to consider is the same income is now going to have to support 2 households. And I often get this question, not question, really statement. The client comes in and I ask, why are you here? And the answer very, very often is, I just can't do this anymore. I want out. I ask people, are you ready to ask for permission to see your children? And they'll say, that'll never happen. The answer is it will happen. Now, jumping forward, and I just want to advocate this, the best kind of divorces are where people just argue about money. When 2 people come in and they say, I'm never going to interfere with the other person's right to be with the children, barring mental illness, barring domestic violence, those are the best kind of divorces. Okay? The statistics on divorced families that keep both parents involved are overwhelmingly favorable to the development of your children. The statistics where one party is actively cut out are pretty disastrous towards the development of your children. With that in mind, I'm going to take you through the structure of the case and what you need to prepare for. So I'm going to go over what you need to gather, what to expect, and how to protect your family. Preparation. The best thing you can do to help your attorney, the best thing you can do to keep your fees lower is be prepared. Be organized. Organization is immensely powerful. Then you're not paying a paralegal to go through cartons and cartons of papers. And this is not a untrue story. More than once have I had clients come in with milk crates or boxes full of papers from years and years. They're completely disorganized. It happens to a lesser extent now in the digital age with people having scans, but what I tell my clients of this. Now, I have a software program my clients can upload their documents, but even better than that, with the advent of Dropbox and Google Drive or any other number of services that allow you to drag and drop your files, you're going to open up your own little Dropbox or get from us or another attorney a link to a Dropbox or some other service, and you're just going to drag those statements over. We'll get into that in a second. But those organizational tools will save you thousands in attorney's fees. Now, financially, what do you need to organize? These are the very basics. At every court is going to have mandatory disclosure, and this is the basics. 3 years of tax returns, W-2s, 1099s, all forms of income. You're going to need pay stubs from the past few months. We say here 6 months is ideal, but frankly, it could be fewer than that. Now, this is the bugger. Bank and credit card statements, because most people don't save them, and very few of us even get paper statements anymore. And if we do, we shred them, we throw them out. So people will tell me that, I can't get them. You can. You have to get on the phone. You have to get them. You can go online. You may have to pay for them. Bank statements, if there's questions of misappropriation of funds, you want to try to get them with checks. Most banks will do it. They'll tell you no, and it may cost, but you have to get them. It's going to help. Your retirement vehicles, 401ks, pension statements, even your Social Security statements once a year. IRAs, investment accounts. You want to get me 3 years of those statements. And you're going to organize them online in your Dropbox, an income folder, tax folder, expenses, assets, debts, business. In addition, what's not here, get your examples of bills. You don't have to get 3 years of them, but we're going to go on to a document you're going to fill out with your attorney called the net worth statement. And if you have examples of these bills, even your food bills, gather them for a couple of months so when you look at them, you have a real accurate picture. I'm going to explain why in a minute. Now, what if you don't have the records? It's more than once that I've had clients come in and say, my spouse did everything. I did nothing. I have no idea where the records are. I have no idea where he or she kept them. I just don't know. And that's okay. We'll find them. But you may know where the banks are. So, not physically, of course, but you may know you bank at Chase or Citibank or TD Bank or something. And if you're on those accounts, you can call and you can get those statements. Even if you have to go in the branch, I don't know the logins, Alex. I can't get them. Yes, you can. You can go there and you can get them. Now, even then, if they don't, we can subpoena them. But I'm trying to help you be organized to save you money. I mean, if we get involved, it costs you money. Your credit cards. I would start with this, and I recommend this to everybody. Run a credit report. There are often times where just with the passage of time, there are credit cards out there that you have a name on and you don't remember, or your spouse opened up without your consent. So even if you think everything is trustworthy, run your credit report. And the material I'm going to give you, there's a free credit report service. I mean, there's several of them that are free. But get it. It'll show you what's open and what's been closed. It'll give you a clear picture. You can contact your card issuers from the credit cards you have, and you can get your statements. Why do we need that? In addition to make sure that we're addressing the debt that occurred during the marriage, because the debt is the obligation of both parties, regardless of whose name it's in. Excuse me. There's going to be spending habits. So sometimes people say, this isn't so much true with W-2 parties, but people who have their own businesses. Your spending is going to be a good example of what people earn. So we have instances, with cash businesses, restaurant owners, plumbers, electricians, attorneys, where there are sometimes cash components that, the party will say they earn one thing and you believe they earn something else. They do through conversations, through spending habits. I mean, if their tax return says 100,000 or 200,000 and they're spending, 25,000 a month, the money's coming from somewhere. And we find that through debt. We find that through the lifestyle analysis, what was paid. If they're spending that kind of money and the debt's not running up, that's going to be proof of that income, at least one way. And look, if you can't find these things, we'll get them. we'll get them. Let's see what's next. So, the preliminary conference. Before we talk about this, we talk about, well, how does the case start? The case starts with what's called a summons with notice and possibly a complaint. Now, when I started practicing, you had to prove grounds for divorce. You had to prove abandonment or adultery or cruel and inhuman treatment. That changed in 2010. Now, New York was the last state in the union that required grounds, no longer. Now, all you have to show is that your marriage has been irretrievably broken for 6 months or more. That's it. There's no other proof. You just say it. So we file the case, we serve the party. Sometimes, if everybody's adults, they'll accept service or their attorney will. So we don't actually have to have the jarring incidents of a process server, meeting a person on the front lawn or at their office. I mean, our office personally, we try to avoid that situation because even though it's par for the course for us, it's extremely upsetting to some people. And understandably, there's marital problems, but you don't want to walk out of your house on your way to work and some stranger sitting there saying your name and then handing you some papers, just like you see on TV. That really does happen. And that creates such an emotional response that the people feel betrayed, even though they know it might be coming. So we try to avoid that. We send a letter to the other party. We ask you to talk to them. There are situations where advance notice isn't a good idea, but usually we try to reach out to avoid that. So the case has been filed. The other side has an attorney or doesn't have an attorney. What's next? We have some preliminary conversations. Say, can we keep it out of court? Can we not? Are we going to move quickly? And we have financial disclosure. So you see here, this net worth statements are filed. Okay. What's the net worth statement? The net worth statement, and talking about this in the context of getting prepared, is what I talked about before. You're putting together your financial picture, and that goes along with all those documents that you're going to collect. It's every asset you own. Now, what people do is they leave things out. I have an inheritance account with my mom or my dad. You still disclose it. All your debt, very, very important. And then we essentially set forth a monthly budget. It's what are our monthly expenses. So we have an expenses section, we have an income section, we have an assets, and we have a liability section. Now, many a case is won or lost based on the net worth statement. I would venture to say it is the most important document filed in any divorce action in all 50 states. People lie terribly on these statements. People think they need to enhance their expenses and fabricate them and blow them up. I don't know why they do that. They're not getting good guidance or they're not represented. So here's what happened. I'll give an example from a few years ago. I had a case in Queens. We went to trial. I represented the wife. We're still collecting child support and enforcement, and we've since locked the guy up twice. Not something I enjoy doing, but the gentleman expanded his expenses to, if I recall correctly, about $15,000 to $18,000 a month. They very well may have been true expenses, but he declared his income to be $20,000 a year. Now, he had cash businesses. He had zero debt. So the question was at trial, and I was questioning more his attorney, is if you incur zero debt and you swear these are your expenses, where's the money coming from? He didn't have a satisfactory answer. Now, here's why it's so important. The court does not have to accept a person's representation of their finances. They can look at the facts. So in the decision after trial, the court ruled that based on the expenses, and he hadn't incurred debt, this man earned, I think it was about $175,000 a year, and support was based on that. He immediately filed an appeal. He lost, and all along, his support was accumulating, and he wasn't paying. We chased him for a couple of years. We had a successful enforcement action. My client was paid in full. Unfortunately, it took locking him up for him to pay. That is the rare case that someone is incarcerated. I'm in my 29th year practicing, and I've only been part of 3 cases where that happened. Usually people come to their senses. And listen, there are some times where somebody doesn't have the money through no fault of their own. They can't work because of injury or something like that. But getting back to the point, net worth statements are critical that they are honest and complete. So, as far as getting prepared, know your numbers, know your budget, know what you're spending every month, know what your debt is. Okay, so what happens next? At the preliminary conference, deadlines are set. This is the first appearance with a judge. You may or may not meet with the judge. The judges have assistants that we call law secretaries or court attorneys, depending on what county you're in. We lay out deadlines. When you're going to come back after your preliminary conference, deadlines to exchange financial information, to file the net worth statement, and if you have children, to basically let the court know, are we agreeing on a custodial relationship or are we not? What if we don't? Then an attorney is likely going to be appointed to represent your child or children. Sometimes more than one, usually it's just one. That is a cost of both parties in a divorce. If you're in family court and you're not married, often the state will pay for that, but not in Supreme Court where the divorces take place. Now, again, if anybody's attending this from out of New York State, I am specifically addressing New York law. So the roadmap. We then come back for what's called the compliance conference. At the compliance conference, the court will ask, have you complied with these deadlines? If not, when will you be? What roadblocks? If we have not agreed on custody, that's going to be addressed. Appraisals and experts. If you have a home, it is likely that that home will be appraised in case one party wants to buy out the other. No party is going to have typically a superior right to buy out the other. The courts generally will force the homes to be sold if there is no agreement, unless you're close to like a high school graduation. You know, if your youngest is like 17, 16, and we're pretty close, the court will say we'll sell it at the after graduation or near graduation, like put it on the market in the spring, so it's done after that. There's a lot more detail when it comes to it, but I'm giving you a basic overview. Discovery will continue. If eventually you're going to be ready for trial if you don't reach a settlement. There's one question I often get, and people will say to me, why do we have to go to trial? It's pretty simple. If you don't agree and the court doesn't have a written settlement agreement, there will be a trial. That's it. That's the end of it. It's either a written settlement agreement or trial. The court will decide for you. And I'm going to tell you what all judges say. You don't want me settling your divorce. You don't want me making decisions because they don't know you. They don't know the intricacies of your life. So I'm going to preach to you now, and I probably have a slide on it. Be reasonable where you can. Our philosophy here is this. Give a little to get a little. From the beginning of your case, your attorney, at least here, we set goals. What do you want to see come of this? Most people say, my relationship with my kids is the most important thing. If there are no kids, it's here's what I want to see financially. There aren't too many surprises we see in these cases. Most attorneys you sit with can predict with a pretty good degree of accuracy where this is going to wind up. Where we have the real fights that take a long time are custody battles. I would say that, except in the cases where you are fearful for your children's safety, let's try to be reasonable. The courts are having a great push towards shared time, if it's possible. That was not the case when I started practice. That was really the unicorn. Now the question is, why not? Why should they have 50-50 custody? Why shouldn't they? People will then have questions, well, if we have equal time, there should be no child support. That's not the case. That's not the topic of tonight's conversation. So let's go on. Now, we're in the case, it's being litigated. What happens with bills? The court generally has a position that you are to maintain the status quo. Whatever you did before, keep doing. Keep paying the bills how you used to do it. If you both put money into a joint account, keep paying the bills from that account. If one party was paying the mortgage and one party was paying utilities, keep doing that. If one party was home raising the kids and the other party was paying for all the bills, keep doing that. You cannot unilaterally change things. I mean, you can, but there's going to be consequences. So what happens if your income changes? You lose your job, something happens. You're going to talk to your lawyer, and then that's going to be the reason for a change in the status quo. But you can't take the law into your own hands. If you do take the law into your own hands, you're going to face a motion for, and there's going to be a court order, there could be attorney's fees. Basically, keep doing it as you did it. Now, there's variance to this, of course. A person might be forced out of a home. There could be an order of protection. One person might just voluntarily leave. You both agree. And then we could have the conversation about who's going to pay for what. General rule, keep paying as you're going. So I mentioned a second ago, if you don't, there can be consequences. So if you're in a divorce, you're going to hear a phrase called the pendente lite motion. Pendente lite is obviously Latin. During the pendency of the action is what it means. So hopefully this is not necessary, because then we're wasting money on motion practice and arguing about the battle instead of the whole war. But all too often, one party says, I'm not paying. Screw it. I'm not going to pay. And then we're going to be in front of a judge really quickly. And the judge will typically issue a temporary order to say, if you paid it before, you're going to pay it again. There's a lot of variance to this. The devil's in the details. And frankly, this is where a lot of attorneys make money, because people are upset and they don't act rationally. And sometimes they have attorneys who won't talk sense to them about what really should be happening. And even then, sometimes it can't be avoided. So if there's a motion pendente lite relief, it could cover a lot of things. It could cover temporary custody. There could be dangerous situations. There's a wide range. I have here exclusive occupancy. It could be dangerous for the parties to live together. You need a motion to remove them. Perhaps their person's actions aren't so dangerous that it rises to the level of the need for an order of protection, but it's inappropriate and they should be removed. So just a quick moment on that. Actually, I'm going to pause on that because I'm going to talk about violence later. There could be a motion for temporary maintenance and child support. Okay, maintenance is also known by that old word alimony. Okay, so those motions are often necessary. Sometimes people come to us even before the divorce starts and said, you know, he moved out, she moved out. They're not giving me any support. I'm by myself. I have no money. I can't pay the mortgage. I can't feed the kids. I mean, those are emergency situations, and we can generally get relief for that person pretty quickly. Automatic orders. You're going to hear about this. When the summons is filed and served, it is noticed to both parties that you can't do anything drastic. You can't transfer assets. You can't name new beneficiaries on your life insurance or your deferred compensation or your pension or your 401k. You can't cancel insurance. God, that's a big one that happens all the time. Somebody files for divorce and the other party who was the provider of insurance for their employment says, I'm taking them off. Can't do it. The court will force you to put it back on, and any uncovered expenses will be yours. You can't go into your account and make a huge withdrawal. That's a big no-no. You're going to be forced to put that money back in. Now, when I say these things, you're going to be forced to. All those things go back to pendente lite motions. There's a little bit of a misconception, and you'll hear it, and I get it in the comments on my social media videos. Nobody's doing anything. If there are violations, if one of the parties is violating the automatic orders, if they're not fulfilling their obligations, we have to bring those issues to a judge. Okay, we can't, nobody's watching this case. There's no monitors by the court. If we don't bring it to the court's attention, nothing's going to be resolved. So back to this, the automatic orders. Basically, you just have to keep living the way you're living. You can't take money out. You can't incur big debt. You can't do any of that. Okay, you can't sell. You can't remove from health coverage. That would be punishable by a motion for contempt. And contempt covers a possible jail time. It's a civil contempt, could be up to 6 months of jail. And usually the person who violates this is going to get smacked with attorney's fees, pretty significant ones. Now, it's a little bit out of order. Custody and parenting plans. Before you meet your attorney, I want you to give thought to what custody and parenting looks like to you. Now, if you can't agree, initial determinations for custody are based on a pretty common phrase that I'm sure you've heard, best interest of the child. Best interest of the child, what does it mean? It means whatever the judge says it means. It's just that. It's defined by those words. It's what the judge thinks. Now remember, we have judges, not juries in New York. No juries in these divorce cases on any issue. And just I should mention this because I didn't mention it before, and I don't think I have it mentioned later. Everything in a matrimonial action is confidential. It's protected from public view. Every filing is protected. No one can look up what's going on. Nobody can look at your assets. In fact, I can upload tax returns with Social Security numbers to your filing in any county in New York, and it's shielded from public view. So back to custody. What does best interest mean? It's a pretty big tent. So first, let me say, put your pencil to paper and say, how do I see parenting work? Custody means three things. It's decision making. It's decision making on religious issues, educational, and health. So when we say there is joint custody, what attorneys and courts mean is it's decision making. And you need to ask yourself, can I get along with my spouse? Can I get along with my co-parent going forward? If Junior breaks a leg, is somebody going to say, don't set it? If Junior, God forbid, has a life-threatening disease, is somebody going to say, don't give them medicine? Usually the answer is no, and we can get along on those three issues. There's a lot of ways to resolve it. There are plenty that say, I can't get along with the person. They're a horrible narcissist. They're mentally ill. They will just fight me. It's not about, they don't really care about the relationship with the kids. They care about hurting me. They see me as the enemy. And I like to think, and I know that that is the smaller portion of the cases that we see, but they take up so much time that it feels like they're the larger portion of cases. But before you come to your attorney or shortly thereafter, put pencil to paper about how you see your parenting relationship with time. Take into account work schedules. I mean, if you have married to somebody who's a cop or a fireman or somebody with a schedule where they work 4 on, 3 off, 2 on, 5 off, 5 on, 2 off, that kind of thing. Look at where their days off fall. Maybe you work the overnights. Maybe you're always home. Look at how schedules play into it. Be reasonable. The court's going to make you be reasonable. If one party comes in and says, this is my kid, you'll get them when I see them, it's not going to go well for you. It's really not. And it's not going to go well for the kids. It's going to be a very expensive divorce. And we know where it's going to wind up. I mean, there are ones where I have somebody who they've been a victim of that other person's aggression and violence, even if it's not physical violence, for so long, they're just beaten down. And it's not limited to women. I've had a client fairly recently, big hulking guy, 6'3", cop, and his wife was maybe 5'3", 120 pounds, and he was so intimidated because she would constantly call the police on anything he did. Nothing ever happened, but he just couldn't take it anymore. And who's the real victim there? The kids. The kids are. What is their view of relationships going forward? Who are they going to choose as their partner? So come in with an open mind, write down what you think is ideal in the best interest of the children, make time for both. And honestly, you're going to enjoy some of that time alone. Address holidays and be reasonable, okay? A basic custody plan when it comes to holidays is, they're exchanged. They're each year. If you're Christian and you celebrate Christmas, you break up 1 year, somebody gets Christmas Eve, 1 year, somebody gets Christmas. And I always do the times at like 10 a.m. exchange. So 1 year, you get to wake up with your kids, and 1 year you don't. Exchange, 1 year you get February vacation, the next year the other person gets, so on and so forth. Typically, we look at 2 weeks exclusive with each party in the summer. You could do more. I have a lot of people that are going to a week on, week off schedule in the summer. It works out real well. Sometimes you don't have the time, and you can't do it because of your work schedule, but there's a counter to that as well. Even if you're working, you have the right for your children to be in your home, just like they're in the other person's home. So have that co-parenting mindset. If you truly can't agree on the decision making on those three big areas, one party would probably have to make sole decisions, or what we often do is say their joint custody, joint decision making. If there is a disagreement, then one party would have final decision making after a notice period. So, for example, ADHD medicine often comes up. People have very, very strong opinions, and it happens very often. Some people say medicate, some people say don't medicate. So in a typical agreement, it would be after consultation with the relevant expert. If the parties disagree upon 10 or 20 or 30 days notice, one party will make the final decision. But that notice period gives you the right to run to court to try to overrule it. It's complicated, it's messy, but this is what we do. Okay. I haven't addressed violence yet. So what I tell all my clients, and I have a policy here, if somebody comes in and they're in danger, they're hurt, we're going to help them get an order of protection even if they don't retain us. So I tell them, don't call me, you call 911 first. If there's violence happening, you've been hit, you've been beaten, you've been hurt, just call 911. Now, in my experience, sometimes, and I mean no insult to any police, sometimes police are less than helpful, or they're viewed that way. Now you got to look at it from their point of view. They're coming, they don't know what's going on. They don't know the history. I've heard your side of the story. They'll walk into a situation, and very often both are pointing the finger at each other. And the cops say, look, if you guys want to press charges, I might have to bring both of you in. Here's my advice to you. If you've been injured, stick to your guns. He hit me, she hit me. I need to press charges because you need safety. Now, unfortunately, more often than not, the cops leave. People say, I don't want to press charges, but then that's not the end of it. You can go to family court the next day, the day after that, the week after that, and say, here's what happened. Document, take pictures, okay? Go get medical attention. And then you go to family court and you can seek an order of protection. And there's two kinds of order of protection. There's ones that order the stay away from you, stay away from your home, and that would result in a removal, or something called a refrain from harassment, where a party says and the court says, look, you must refrain from acts of violence, stalking, menacing, harassment. There are advocates. There are a lot of sources available. If you let violence happen, 9 times out of 10, it's going to happen again. So I'm going to get off my soapbox then. Now, quick view on child support and what to be prepared for. What is it going to look like? This is a little bit overly simplified. So CSSA stands for Child Support Standards Act. There's a combined income calculation. FICA is removed from your gross income, and then these percentages are applied. If you have more than 5 children, it stays at 35%. And there are add-ons. You're still responsible for your share of childcare, insurance, unreimbursed medical, and educational expenses. We could get into college real quickly. Basically, you're going to be responsible for your share of college as well in most cases. Tuition, room and board up to the cost of a SUNY education, State University of New York. Whatever you pay towards room and board would come off your child support obligation, basically. So quickly about maintenance. Now, maintenance statute came into effect quite a few years ago. It was tax exempt. It has not been tax exempt. I'm sorry, not tax exempt, deductible. Take it as a deduction. It has not been since 2016. We're hoping that changes because it gave us so much flexibility. So there are statutory formulas based on both parties' income. It's a mandatory calculation up to a person's income, up to, I believe it's $228,000. Basically, the closer you are in income, the less likely there is to be maintenance. But if one party makes $50,000 and other party makes 200, there's going to be maintenance. The length of maintenance depends on how long you've been married. It starts at, if you're only married for a few years, you're only be liable for a little bit of maintenance. If you've been married for 25 years, you're going to be liable for quite a few years, maybe 9, 10, 11 years of maintenance. And the factors are marriage, or the length of the marriage, health of the parties, the earnings. To go above that cap of the person's income at 228, courts will typically always do it for child support. But someone will ask me, say I make $1 million a year, am I paying child support on my entire $1 million of income? Almost always no. We'll find a cap and lower it. Right now, the courts are typically using around anywhere from 275,000 to 350. It could be more, but that's where we look at a person's lifestyle. I mean, are you jet setting around the world with your kids, or do you guys save? And life is so expensive, you're kind of spending everything on just necessities. So that's that. Now, what if there's a business involved? What do we do? First, was the business started during the marriage or before the marriage? But getting prepared for this, and this valuation of the business, what's got to be turned over? Tax returns, profit and loss statements, balance sheets. Really, checking statements is what these appraisers want to look at. What typically happens is, unless parties agree that there's not going to be a division of this business, the business is evaluated. A neutral evaluator is appointed by the courts at the cost of the parties. If one party is the primary breadwinner, they may be paying more than the other person, likely. If it was started during the marriage, it absolutely is going to get evaluated. I mean, you have cases where parties are just 50-50 owners. I have one going on now. And they're involved day to day, but more often than not, one party has a business, one party either stayed home or they have another job. So the business will be evaluated. It doesn't mean the non-owner is going to get 50%. It's actually usually a lot smaller because it's based on the contribution to the business. And they also may be getting compensated through maintenance or some other division. Okay. But the question comes up, what is a person hiding in that business? Because frankly, a lot of people use it to pay personal expenses and they shield them through the business, and that evaluation of that forensic expert will ferret that out. So in getting prepared, which is the theme of this webinar, is get copies of records where you can. I've had books of estimates been brought to me to be copied, cash receipts that will never show up in a tax return. The more you look, the more you'll find. Now, even with a cash business, experts will do an income analysis based on statistical data across similar businesses across the country through years and years of data and experience and shared information with other evaluators. And people think that, God, I'll never be able to prepare. I'll never be able to show what he earns or she earns or what it's worth because it's cash. What are we going to know? More than you think. We know of a certain volume of a landscaper or a sheet metal business or an accountant. We know with a pretty good degree of accuracy what that business is going to be worth after these appraisals are done. Okay, preparing for divorce. This is one of the biggest questions. What do I do about my inheritance or gifts or whatnot? PI stands for personal injury award. These are classic examples of what we call separate property. Something you received pre-marriage, something you earned pre-marriage. You bought a house premarital. Inheritance. Now, the big rule of thumb is, did you commingle it? Did you add your spouse to the deed? Did you take your inheritance? Did you put it in the joint account? So those may make those things become marital property. And what you need to prepare, again, the theme of this is preparation, is you need to show a paper trail. So I'll give one example. I mean, it's pretty easy with a deed. Those are public record, but had a case 3 years ago where a gentleman took his inheritance and put it into a joint account. It basically sat there, but they both continued to contribute. Now, many years had gone by, and he had to go through heck to try to find the original statements that he contributed to those accounts. So it's finding those contributions to the extent that marital money was contributed to that account. We had to explain it. We were actually successful in that in a settlement, and we got credit because we were willing to go to trial and the other party wasn't. But documentation is the key. Don't throw out those documents. If you do, go find them. And a lot of banks will tell you, sorry, it's more than 7 years, I can't find it. Generally, they will be pretty stubborn. If you raise holy hell, you might be able to get them to get the documents because they do exist. It's a digital age. these banks, these financial institutions, they don't get rid of them. They say they do, they don't. Okay, so commingling. So if there's any military people here, and especially Navy, my father's a Navy man, there's a saying that 1 teaspoon of oil can ruin an entire tanker's freshwater supply. So that's what you look at commingling like. If you commingle marital assets with things you are trying to keep separate, it can result in what's called transmutation, where a court could view that as entirely marital property and you've lost separate property status. The courts in New York have some room because we are what's called an equitable distribution state, not an equal distribution state. Okay. So it's something to be avoided. It's something that if you have inheritance coming up, keep it in your own name. There's no reason to put any other money in there, not even your earnings. If you put in your earnings from your marriage, your individual earnings, that's marital money being contributed to a separate property. So keep those separate. What do we do? So as far as retirement goes and what we're looking at for division of assets, it's only the marital portion that's distributable. So as I was just saying, you want to get the premarital states. The next question is, how do we divide the marital portions? So you see a word here that you'll see often if you're in divorce. It's in the Majauskas formula. Majauskas is the name of a case that went up to our highest court, the Court of Appeals in New York. So we refer to it as the Majauskas formula. Basically, it's number of months married, and the denominator is the number of months you put into that plan when it comes to a pension, and that gives you a fraction as to what's the marital pension. When it comes to 401ks or IRAs, it's a little bit simpler, but you have to get the data as to what your premarital balance was. So if you worked for a number of years and you have a balance you got married in 2010 and now 2015, you had contributions from 2000, 2010, so 10 years of contributions, and you had 15 years of marital, you want to get that starting balance, and then we can do a passive gains or losses analysis to preserve what is your separate property. So again, as far as preparation goes, you've got to find out that information. And there's several ways to do it. I mean, you can go back to the institution and get the statements. I had a client recently, he was able to show through he kept all his tax returns and showed all his contributions, and he made maximum contributions every year. So we may not have gotten every dollar, but we're able to mathematically show what his balance was, at least from principal contributions. Okay. So I've been talking almost 50 minutes now, and I want to leave time for questions and answers. So mental health and well-being. So what I tell to people is, and I'm quoting a friend of mine, everybody needs a checkup from the neck up. I tell every person that comes through this door, get therapy. You think you don't need it. I will tell you that you do. None of us have been through this before. Even if you have been through it before, you need an objective opinion, because this is like losing a loved one. It's like somebody dying in your life. So especially on the theme of preparation, are you ready? Sit down with a therapist. Get an objective opinion as to where you are, your behavior leading up to this, your partner's behavior. Are you sure this is the path? During the divorce, you need it even more. You're going to face stresses that you've never faced before. Okay? So many things you're facing. Maybe you've been known by one name for years. Are you going to change your name? 2 different households. Maybe your kids are gone for days at a time. You're going to feel very upset and lonely. You're going to need somebody to talk to. And the friends and family are not the ones. They can provide some help, but they don't provide objective help. Courts don't see this as a weakness. I'm in therapy. The court's going to think I'm crazy. Obviously, that's very antiquated thinking. Courts will view you seeking help for yourself and for your kids extremely positively. I encourage you wholeheartedly, seek therapy. Again, even if you think you don't need it, you do. If your children, frankly, I think all children going through divorce should speak to a therapist, because they may seem okay, but they're not. They're sponges. And more than anyone, they will be quiet because they don't want to upset you. Because frankly, all kids think the divorce is their fault. You don't know that. They're going to be tough little soldiers. And I'm going to take a minute now. I didn't have it on one of the slides. but I'm going to talk about something called gatekeeping. Gatekeep, Gatekeeping is the worst kind of behavior in a custody case. And what's an example of it? I mean, there's some obvious ones where you're standing in the way of the other party seeing the children. You're canceling last minute. They're sick. You can't see them. Scheduling activities during the other person's time. Scheduling parties without them knowing. Oh, my family's coming over. And the worst part of that is they get the kid in the middle. They get the kid all psyched up. Well, grandma, grandpa are coming over on Friday night. Oh, it's your dad's time, but you don't want to see grandma and grandpa, and then get the kid on the phone to say, tell dad, tell mom I'm not coming. That is the worst kind of behavior and just so damaging to the child to put them in the middle. It's just so damaging. And I'll tell you, the judges see that, they are going to be pissed. Are they going to do something about it? In the context of a custody case, that kind of behavior is going to be reason for the other party to be the custodial parent. The other kind of passive gatekeeping, little Johnny or little Jill comes home for visitation. I shouldn't say come home, comes back to the other party. Oh my God, where were you? Oh, I missed you so much. I miss you so much. You didn't have any fun, did you? Oh, did they take you to the beach? You don't really like the beach, do you? You didn't have any fun. Well, they only fed you grilled cheese. God, hungry? That's not your favorite. Oh my God, you're dirty. Did you even shower? Did your father even shower you? Did your mother even shower you? Who was around you? Who was there? See, that's the kind of passive interrogation. That's not so passive, but gatekeeping, that you're not saying your father or mother is a terrible person, but you did. And that kind of stress just wears a kid out. And frankly, it may turn a kid, but the court's going to see that kind of behavior. And again, your job, if you're, say, the primary custodial parent, one of your prime jobs, and I've won cases, quite a few on these, your job is to promote the relationship between the children and the non-custodial parent. If you violate that job, it's going to be exhibit number one in your custody case. Okay, so going through this, I talked about this before. Are you ready? Is this a reaction, or are you making a recent decision? Have you tried counseling? If one party's not going to do it, there's not much you can do. And this buzzword, communication. Now, this I think takes, and I say this only after doing this for so long, we have bad communication. Part of having good communication is listening, not just sitting down and having a talk. It's listening, even to things that you think the other person's wrong, hearing things that are really hurt, and without having a reaction, without screaming, without yelling. That's 50% of communication. It's hearing the stuff, even if you think they're wrong, even the stuff that hurts. Have you tried it all? If you have, maybe you're ready. Some marriages do end. It does stink. Just a quick percentage. Less than 50% of first marriages go to divorce. It's down to around 42%. The divorce rate is falling. And I just want you to consider, people, before you come in, do a budget. What's it going to take to run your new household? And just as an aside, people always underestimate their food spending, like massively. People come in and say, I spend $100, $200 a week. No, you don't. You spend a heck of a lot more than that. Okay. Share everything with your attorney. Be ready to disclose even your mistakes. Respond promptly to your attorney's requests and demand that they respond promptly. It might not be within minutes. In the age of text messaging, people get frustrated if we don't respond in a couple of hours, but each of us carries quite a few cases. So sometimes we can't. So just don't be insulted. Stay organized constantly. It's going to save you money. Social media, stay off it. Those become exhibits. It's just, don't share your thoughts with other people. Don't post the other person's a bad person. Stay off it. They really do become exhibits. Okay, so prepare, don't panic. Focus on children, long-term stability. Yeah, have a clear plan. I'm leaving this up there if you want my information, but I'm going to stop. I'll put this up there again in a second. Everybody who signed up for this, I'm going to send the manual, which goes into much more detail. I'm going to invite each and every one of you. We're going to send out an email. I'm going to do Q&A in a second. All of you can have a one-on-one consultation with me. We set it up via Zoom. I'm not here to sell you. If you want to hire us, that's great. The purpose is to give out information. Take it to another attorney, that's fine. We really just do this, want to help. And of course, talk about ourselves. So let me just stop sharing here for a second. Let's start the Q&A. Okay. Now, if you have any hands, if you have any questions, you can answer them now. There should be a text box for you to answer, to pose a question. Okay, first question. What's uncontested versus contested? An uncontested divorce is where you agree on everything. I get these questions all the time. Alex, I'm calling you. I want uncontested divorce. I want you to have an uncontested divorce. But an uncontested divorce is where you agree on everything. Everything. Every single thing. Support, custody, split of assets. If you don't agree on everything, you don't have an uncontested divorce. You have a contested divorce. What does a divorce cost? It's really based on time. How long are you going to fight is how long it's going to cost. What we bill for is our time and our hours, every little thing. Some lawyers, I'm not a fan of them bringing two attorneys to bill. I think that's unfair. If you have a very complicated trial, you need two attorneys. That's something that should be discussed, and that is necessary sometimes. Next question. How long does an uncontested divorce take in New York? Okay, so that varies by county. Right now in Nassau, there's two parts to it. How long do you take to negotiate the terms? So let's say you get everything negotiated and you answer in a few weeks. Oh, you just type Queens County. Queens is a big backlog. Big. Queens is probably the longest in all the states that I've practiced in. Queens is messed up, to be perfectly honest with you. And you're stuck with it because you live there. So once you're signed, you're probably looking at minimum 7-8 months, maximum a year. That brings the question, how do you file your taxes? If you're still married at the end of the calendar year, you can file jointly. You will still be married. Can you file in another county? Yeah. So that's a weird answer. Under the law, yes, but all the counties, there's a couple of them upstate that allow you to do it, but excuse me, a rule came down from the chief executive, the chief administrative judge in New York about 2 years ago. Counties are bouncing you if you don't both live there, or at least one of you live there. They'll bounce you. I had an old partner that had loved to file everything in Suffolk County because that's what's convenient for him. And then Suffolk caught on, and they just started bouncing them. You're welcome. Okay, so any other questions? That's kind of one that Seabrook calls, whoever typed that call me outside this and I'll meet with you. Okay, this gentleman asked another question. How long for a contested divorce? So my oldest case is from 23. A lot goes into that. I mean, if you have a complicated financial matter, a complicated custody matter, it's going to take a while. I have other cases that are done in a year. You're supposed to be trial ready within a year. Do cases take longer? They sure do. Okay. Last question. Can a person stop working to avoid support? No. The court will look at their earnings history and they will do what's called imputing income. So a person has a history of making $150,000 a year, and they just suddenly stop working. The court's going to presume they can still make that money, and they will make that money. Frankly, if they lose their job through their own actions, even even addictive behavior, a court can say that's your problem. You still have a support obligation as to that amount. Does overtime count in support calculation? Yes, it does. Overtime, sales, income from all sources, even if it's past income, counts towards support calculations. Okay, I hope you all enjoyed this. I don't see any other questions. You're all going to get invited to set up a consultation if you wish. If you don't, that's fine. I'll send you all the manual as well. I hope you have a fantastic night. I really wish you all the best. Make good decisions. If you have any questions, feel free to reach out to us.